Hello. Well, good afternoon if you're on the East Coast, and good morning if you're way out west. My name is Aaron Lacey, and you're listening to a review of the U.S. Department of Education's new third party servicer guidance and suggestions for public comment, which is brought to you as part of the Thompson Coburn Higher Education webinar series. We're glad you're with us today. While folks are still joining, I'll go through some of our housekeeping. First of all, if you have any questions during the webinar, you can submit those through the Q&A widget at the bottom of your screen. And at the end of the webinar, we were intentional about choosing 90 minutes. We think there will be some questions, and we want to try to get to some of them. So we will be collecting those there, and at the end of the webinar, we'll try to start working our way through. A copy of today's slide deck is available in the resource widget, and I encourage you to grab that and download it. We've got a lot of live links, as we often do, in our webinars, which will take you directly to some of the resources that we're referencing on the U.S. Department of Education's website and elsewhere. You can find additional answers to some common technical issues located in the Help widget at the bottom of your screen. And if you are an attorney and you're tuning in for continuing legal education credit, the webinar is CLE accredited in California, Illinois, and Texas for 1.5 hours of general CLE credit, and in Missouri for 1.8 of general CLE credit. We're also CLE accredited in New York for an hour and a half of experienced and transition credit. Just keep in mind, we award CLE based on attendance for the entire 90 minutes. Due to some jurisdictional requirements, we will display secret words, 3 of them, in a multiple choice poll during the webinar. So particularly if you're an attorney looking for CLE credit, when those pop up, make sure you hit the little radio button, thereby indicating that you are still engaged. And at the end of the webinar, there is a survey. We are extremely grateful to folks who stick around and fill out the survey and give us ideas and feedback. As I say every time, we really do review that feedback, and we always try to make each webinar better than the one before. If this is your first time joining us, just to be very clear, Thompson Coburn is a law firm. And so everyone who's presenting today, we're all attorneys. We're a pretty big law firm. We have about 400 attorneys and offices coast to coast. And we have a higher education practice, which means we have a group of lawyers who dedicate all, or in some cases, most of their time to serving institutions of higher education, and in some cases, servicers that provide services to institutions of higher ed. My name is Aaron Lacey. I'm the partner and the chair of the higher education practice, and have spent my entire career working with institutions of higher education and do a lot of different things, but really focus on federal education regulation and policy. I'm joined today by 2 of my colleagues. One is Scott Goldschmidt, who's the former Deputy General Counsel, Catholic University, was in-house for about 8 years. So for those of you who are right now on the other side of the private lawyer institutional fence, certainly appreciates what that's like to hang up the phone and have to figure out what to do with some of this guidance and these regulations that are coming your way. We're also joined by our colleague, Hope Watson, who works in the higher education practice as well with lots of institutions and frequently on state and federal regulatory issues. Here's the syllabus for today's presentation. We're going to start out by defining third-party servicer, and then we're going to move to sort of the responsibilities in third-party servicer relationships. And then we want to talk a little bit about the prior TPS guidance leading up to the recent new third-party servicer guidance that came across the transom in February. You know, we're pretty intentional here about wanting to start with a discussion of what's in statute and regulation and what was in prior guidance in particular, because the second half of the presentation is really dedicated toward talking about the new guidance, how to comment, and suggesting or making recommendations for comment. Now, we'll discuss a little bit later. The deadline for comments is this coming Thursday. And I know some of you are saying, Aaron, it's Monday and you're giving us only 3 days to put together comments if we want to. But I assure you, a page of comments, a paragraph of comments can be worthwhile. They don't have to take any particular form. They don't have to be written by lawyers. And we think there's plenty of time to still put something together that's meaningful and could provide useful insight to the department. But when you're formulating comments, we also think it's just terribly important to have some understanding of, you know, why is the department doing what it's doing? What's its motivation here? And what is in statute and regulation, and what is strictly new guidance? because it's one thing to try to suggest to the department that they should change something that's hard-coded into a statute. I mean, they really can't, right? But if it's a position that's not backed by statute or guidance, or regulation rather, and has never appeared in guidance before, that means it's really brand new and not particularly supported. And it might be a really good opportunity to try to get the department to rethink whatever it is the position might be that they're taking. So in order to do those kinds of things and to approach comments in the most effective manner, you really have to know what's in the statute and regulation and what's brand new and why is it out there. So let's start by defining third-party servicer, and I'll take this first leg. The most important thing to appreciate is that though for some people we have discerned recently the third-party servicer concept seems to be new, it's not a new concept. It's actually been in the law for decades, and it is rooted in statute. There's a definition of third-party servicer that Congress put into the Higher Education Act. The term third-party servicer for the statutory language means any individual, state, private, for-profit, nonprofit organization that contracts with an institution of higher education to administer any aspect of the institution's student assistance programs under, in the chapter there, we're talking about Title IV. Now, a couple of things I want to hone in on here. I mean, the first thing is, because it's going to come up later in our conversation around, sort of what the department is doing here and how they're justifying this expansion of the concept of third-party servicer. But it is true that in the statute, it does say any aspect, right? But it also says of the institution's student assistance program. So I want you to just keep both of those phrases in mind, any aspect and student assistance programs as we move forward. All right. As is often the case, Congress has this idea that it puts in the statute, and then the U.S. Department of Education promulgated regulations that to some extent repeat the statutory language and then expand upon it. So the regulation says, yes, once again, a third-party servicer is any party out there, for the most part, that enters into a contract with an eligible institution to administer any aspect of that institution's participation in any Title IV HEA program. Now, recall the statutory language is a little different. Remember, we just talked about that. It said student assistance program. Here it says any aspect of the institution's participation in any Title IV HEA program. But then the department and the regulation goes on to say, well, but we'll tell you what we mean by that. Okay, so what we mean by that is performing a function required by any statutory provision or applicable to Title IV of the HEA, any regulatory provision prescribed under that statutory authority, or any applicable special arrangement, agreement, or limitation entered into under the authority of those statutes applicable to Title IV, right? So what the department says is, when we're talking about any aspect, of the institution's participation in Title IV, we're talking about the stuff that the institution's required to do as part of its participation in Title IV, either under statute or regulation or some agreement that was put into place under that statutory or regulatory authority. The regulatory language also specifies that employees of an institution can't be third-party servicers or are not third-party servicers to those institutions. Now, the regulation goes a step further, helpfully, and says, so we've given you this sort of idea about what we mean, and now we're going to give you some examples. It's not an exhaustive list. It's an illustrative list, but it's pretty instructive. When you look at this, processing student aid applications, performing need analysis, originating loans, dispersing or delivering Title IV, loan servicing and collection. It's pretty clear if you look at all these examples that most of them are exactly what we would expect them to be, and that is services that relate directly to the processing of financial aid, right? So far, when you look at the statutory and regulatory language, we see Congress saying any aspect of the student assistance programs, and we see the regulation saying, well, any aspect of the institution's participation in the Title IV programs. And by that, we mean the stuff that they're required to do under statute or regulation as part of the Title IV programs. And here's a bunch of examples, and it's all federal student aid type stuff, processing applications, servicing and collecting loans. And then there are a handful of carve-outs. Interestingly, the regulation chose these 6 things to say, just to be clear, these are not third-party servicer functions. And what's particularly interesting, if you look on the bottom row to the right, warehousing of records and providing computer services or software. So the regulation actually excludes providing computer services or software and warehousing of records from the definition of third-party servicer. But as you are probably already aware, if you've read the recent guidance, over recent years, even going back as far as 2012, the department has said, well, okay, so the regulation excludes record keeping and computer services or software, but in some cases, you would still be a third-party servicer if you're providing these types of functions, and we're going to give you a little more meat on the bones if you're trying to decide what that means. But here again, most of what we're seeing in this conversation in the statutory and regulatory language seems pretty focused on and suggest what we would consider a classic idea of a third-party servicer, meaning an entity that's helping an institution manage its student aid programs. With that, I'm going to kick it over to Scott to talk about, if you are a third-party servicer, what does that mean for the institution and for the vendor?
Perfect. Many thanks, Aaron, and a pleasure to be here with everyone to discuss this. And now that Aaron has defined what a third-party servicer is and what it means, both in statute and regulations, let's talk about what's the big deal, what are the responsibilities for both institutions and the third-party servicers. Let's start with institutions. So the first big kind of highlight, big flashing point that we want to make, and this is directly out of the regulation, is that even though the department has decided or trying to maybe share liability or have third-party servicers join in liability, schools are ultimately responsible for the use of Title IV funds. They're held accountable. Even if the third party's mismanagement led to the liability, the department has this backstop. It is ultimately the institution that has that liability. Super important when institutions are considering who they want to contract with, because if you're ultimately on the hook, regardless of any contractual provisions and risk sharing and that kind of those kind of risk management, per the regulations, institutions are the ones responsible. There's also notification requirements of TPS relationships. So schools have an obligation within 10 days of new contracts, termination of existing contracts, and substantial changes to current contracts to notify the Department of Education. And we'll talk about a little later how that works and kind of why it's certainly a big deal when entities that are not third-party servicers or haven't been considered third-party servicers in the past are now kind of subject to this new guidance, and both the third-party servicer and institutions are kind of left scrambling potentially within this 10-day window to determine who should be reported. Another piece that we talk about with our clients, it's a little lesser known, it's part of the guidance. I definitely would encourage institutions to review this, is the certification by lower contractor form. So all these requirements for institutions, one of them is each contracted TPS, as well as each subcontractor that performs work on behalf of a TPS is required to sign this certification by lower contractor form. That's found in the appendices of each institution's program participation agreement. One point to consider kind of how institutions identify subcontractors and kind of making sure they're complying with this requirement. But suffice it to say, for these purposes, that is a requirement you should be aware of. And last, which we'll talk about on the next slide, there are a number of required clauses in contracts, and institutions have to ensure that their contract includes those clauses that cover liability, compliance, reporting, records, and responsibilities. And for entities that are now covered under this third-party servicer guidance, whatever goes into effect September 1st, which we'll talk about, contracts may have to be amended. So here is a chart. I won't read this verbatim, I promise. The regulatory site is found at the bottom. So if anyone has any interest in going to see more, you can go check that out. And here are the required contract clauses that have to be in any third-party servicer agreement. So the third-party servicer agrees to be jointly and severally liable. So again, even though the institution is ultimately responsible, the third-party servicer has to agree to be jointly and severally liable with the institution for any violations of federal financial aid Title IV requirements. Third-party servicers have to comply with Title IV requirements, including audits. They have to agree to refer fraudulent activity, criminal activity to the Office of Inspector General, confirm student eligibility and return of Title IV funds, for the classic third-party servicers that are helping institutions administer their federal student aid programs. And they have to agree to return records and funds and everything that if the contract is terminated, they need to provide back to institutions. So even though we have a regulation on the previous slide that has these contractual terms, the department said, wait, there's still more. In guidance, they say we have other contractual clauses, requirements, or not necessarily contractual clauses, requirements in this guidance that need to be part of an institution's relationship agreement with a third-party servicer. So this is found, you have to accurately and specifically detail the functions that perform. You have to identify the third-party servicer by name, provide the address and phone number, identify each subcontractor, and must require that third-party servicers agree to comply with FERPA, and third-party servicers must agree to comply with the FTC information security requirements for financial institutions under Gramm-Leach-Bliley. A shameless plug for a webinar we're hosting tomorrow, actually, on these requirements. So a couple of our colleagues are going to go over the GLBA changes. As you may or may not know, June 9th, the FTC's safeguards rule goes into effect. The department is going to be auditing this requirement. That one was scheduled well before this, but we certainly wanted to get this webinar in time for comments. But to the extent that anyone on the call has interest or questions about the Gramm-Leach-Bliley Act and its obligations, please tune in tomorrow. And last, so those are the institutional requirements. Just briefly to go over the third-party servicer requirements. So the third-party servicers have to agree to those clauses that we discussed or that are in regulation in the previous slide. They have to agree to potentially be subject to independent audit and program reviews. The audit requirement, to the extent there is an audit guide, and to the extent that a third-party servicer meets one of the criteria in the audit guide, they have to go through an independent audit. If they do not meet one of the criteria, then they need to submit a letter. But a potential obligation for third-party servicers there. Institutions can't knowingly contract the third-party servicer that has been terminated, committed fraud, suspended, or debarred by the department. If there is an issue with the third-party servicer in the department's estimation, the department does have the authority to initiate fine, limitation, suspension, or termination proceedings, so another kind of important hook. And third-party servicers are required to submit a data form. This form is found, or a draft of this form is found at the bottom of the current guidance, or the guidance that we're discussing in effect. So the institution has a requirement to report third-party servicers to the department within 10 days. The third-party servicer has the responsibility to submit this data form to the department to provide information about their business. And with that, I'll turn over to Hope.
Great. Thank you so much, Scott. So today is our first secret word. Today is regulatory. So for CLE purposes, please select the correct word from the radio buttons below, and we'll take about 30 seconds to do that before we continue on.
I do feel like we need to Jacob, our producer, I'm going to give him a hard time. I think we need to come up with some more creative secret words. Regulatory seems a little too obvious to me. So maybe next time, Jacob, we'll convene. We're going to have to do maybe some March Madness or something like that for the next regulatory word.
Maybe some music too, Aaron. I don't know.
That's true. I could get out the ukulele.
Just a few seconds more to get that in. Okay, we will move forward with the presentation. So before we get to discussion of the new guidance, we want to walk through the prior guidance of the department to kind of give us a sense of where we came from so we can understand better where we're headed. And as we talk through this history, I want to call special attention to a theme that the department has adhered to with each new iteration of guidance on third-party servicers. So this started back in 2012, well, the first guidance we'll discuss started in 2012, but the concept of third-party servicers entered the regulatory framework 2 decades ago. And during that time, up until 2012, we were specifically talking about people who managed financial aid as being covered by that definition. 2012 was the first time that the department determined that there were parties engaging as third-party servicers who were not presently covered by the definition. And in this case, at that time, there were a number of banks and financial institutions that had created debit cards for student credit balances. So instead of cutting a check, the student's credit balance would go onto these cards. And the department, in its discretion, determined that issuing credit balances was very clearly managing financial aid. So the department expanded the definition of third-party servicers via the 2012 guidance to include these banks and financial institutions. So the reason we want to call this to your attention is to note that 2012 was the first time that the department was troubled by a specific sector, in this case, the financial institutions, and the department determined to expand the guidance to cover that specific group. We see a similar move by the department in 2015. In that case, the department was troubled by which computer servicers and software providers fit within the third-party servicers definition. And there, the department took specific action to expand the definition through the 2015 guidance to include those entities. We want to emphasize this approach of the department because when Scott talks about the new guidance in just a few minutes, again, it will be clear that this is a common theme. We have a specific group that the department is troubled by, and then the department uses the tool of guidance to expand the definition of third-party servicer to encompass that group. So as you begin thinking about comments, which we will also discuss later in the presentation, it's important to think through the lens of this theme, meaning that the most effective comments will be those that propose ideas to the department that understand this motivation to move new groups into the third-party servicer box and that do not undermine that stated goal. It's a fine line to walk, but we believe those will be the most effective comments. This same theme continued in 2016. So that year, the department issued a lengthy 22-page Q&A. And if you've had an opportunity to review the most recent guidance that we're discussing today in this presentation, you've actually seen most of the 2016 guidance. So it's important to understand that the new guidance document and its accompanying chart, which Scott is going to walk through in short order, is very similar to the 2016 guidance. In fact, roughly 80% of what we see in the new chart and guidance we saw in 2016. So the new guidance isn't really all that new. So with this in mind, please note that even if the department rescinded this most recent Dear Colleague letter, it wouldn't make much of a difference because 80% of the guidance is already on the books in the form of the 2016 guidance. So comments asking for a rescission of this most recent DCL are maybe not as strong as comments that will be formulated according to what we'll lay out later in the presentation. And as far as what was introduced fresh in the 2016 guidance, this is the first time that we saw the introduction of the concept of the foreign-owned third-party servicers. And we see that show up again in this current guidance. Of course, taken on new meaning now through the expansion of this concept in the new guidance, which Scott is going to walk through, but we wanted to note that the first time we saw it was in 2016. And the last thing we'll note that distinguishes the 2016 guidance from the current guidance is the current guidance is the guidance that introduces the concept of the recruiting, retention, or instructional concept third-party servicer. That did not appear in the 2016 guidance, and that's fresh here in the current guidance. So with that, I'm going to turn it over to Scott to discuss that guidance.
Thank you again, Hope, for that great overview. So now let's talk about kind of why we're here, this new third-party servicer guidance. But before that, we do want to comment on a rulemaking that is going to occur later. So why we're here is this Dear Colleague letter that has been promulgated, and I promise we'll go into great detail on that. But really important to note that the department has indicated that they are going to review and provide and issue regulations and actual regulatory rulemaking on third-party servicers. In this slide in the right box, you have a screenshot of the unified agenda of regulatory and deregulatory actions, which is a fancy-sounding name, but basically is the current administration's actions of what they propose to do in terms of agency rulemakings. And each department has their own page. This is the department's rulemaking, as you can see. And if you watched or listened to our previous webinars, the department has been extremely busy rewriting a lot of rulemakings, Title IV and otherwise. But one of them coming up in next month is a rulemaking on third-party servicers. So with that background and with that kind of knowledge in the back of our head, the department still decided last month to issue new guidance. So that was promulgated on February 15th, 2023. The department kind of dropped this kind of regulatory bomb, if you will, that kind of shook up the higher ed community, that detailed new requirements and responsibilities for third-party servicers and institutions. In that guidance, the department took the position in that February 15th guidance that it was effective immediately. Institutions had to kind of quickly digest and comply. And as I mentioned before, there were a lot of concerns and issues with this new guidance, one of them being the 10-day requirement that institutions have to report new third-party servicers. And as we'll certainly detail, many entities that were not covered previously would now be considered third-party servicers under this new guidance. So there was a uproar, there was significant feedback, there was pushback on the department kind of in a 2-week period. And the department, to its credit, kind of understood maybe they weren't as targeted as they should have been in this guidance. Maybe they kind of went a little too far with this, just kind of making it effective immediately. So what they did, they didn't change any examples or any of the substance, but basically took a step back and said, we're going to press pause. The effective date of this guidance is now pushed back to September 1st, 2023. As of this date, the guidance that Hope talked about, the 2017 guidance is still in effect. And we're going to hear from the regulated community. There always was a comment period, but this pause will give the department a chance to review those comments and potentially make changes based on them. There were a couple areas they specifically called out in the guidance that were brought up to the department, and that theoretically is good news, that the department is going to consider this seriously and make changes based on what they're hearing. So as Hope mentioned, a lot of the guidance was the same, but it really dramatically changed in a number of ways. So basically the concept, the definition of a third-party servicer in general was significantly expanded. So in the letter, in this Dear Colleague letter, the department proposed that third-party servicers now would include vendors that assist in recruiting, retention, or delivery of Title IV eligible education programs. And we'll go into that a little bit later in the presentation. And it also insinuated that a range of vendors providing software solutions, consulting, and auditing would also be kind of swept up in this definition. And as you can see, and we'll talk about, the department's kind of moving away from the classic financial aid management specific, as Aaron mentioned, the student assistance program statutory definition into areas such as recruiting, retention, and delivery. So we're really kind of expanding the box here. And as every one of those calls, I'm sure could think, there's a lot of entities that are involved in those activities in recruiting and retention that would not have considered themselves to be a third-party servicer on February 14th, but now kind of have to work within these new rules and regulations. As Hope mentioned, one of the aspects of the department kept in is this foreign ownership prohibition. So in this guidance, this started in 2016, the department maintained in this 2023 through guidance that institutions can't contract with a third-party servicer if the third-party servicer or its subcontractors are located outside of the U.S. or owned or operated by an individual who is not a U.S. citizen, national, or lawful permanent resident. Now, even though this theoretically has been in place for 8 years or so now, the definition of third-party servicer before February 15th was fairly narrow. Now that the department is proposing to expand the definition and cover a lot more entities, this becomes a real problem for a lot of foreign-owned entities and entities that provide third-party servicing. This is actually the one example where the department specifically calls out in their guidance that they want to hear from the regulated community about. This is now in the updated guidance, and it certainly suggests the department maybe realizes this is maybe a step too far, certainly an existential threat to foreign-owned entities, and potentially considering that the department will put a tighter box around this or potentially change this in the forthcoming revisions, which we expect and hope. Aaron, in the final section where we detail potential suggestions for comment, will explain that this is, even though we might expect it to be, this is not a concept grounded in statute or regulation. This is a policy position by the department that they instituted in 2016, and one that potentially they might have to revise considering the uproar they're getting. So, their authorization. So the interesting piece is in the Dear Colleague letter is how the department got from these classic third-party concepts, so financial aid management and Title IV activities and kind of directly administering a Title IV program, to retention, recruitment, kind of institutional activities. The justification the department gave is kind of right up front, and it's only one sentence. And they explain, and this is really important why we highlighted it in red, they say most activities and functions performed by outside entities on behalf of an institution are intrinsically intertwined with the institution's administration of Title IV programs, and thus the entities performing the activities are subject to TPS requirements. Now, this is an extraordinary statement. So basically, they're saying that we have the authority to regulate any outside entity that contracts with an institution because their services are intrinsically intertwined with the administration of Title IV. That is the justification they are using to kind of bridge the gap between the statutory language, assistance with administer a student servicer program, the regulatory language, administer a Title IV program, to kind of these broad concepts. Now, there's certainly up for debate and interpretation about kind of where the appropriate line should be drawn. Our opinion, and this might be an appropriate kind of place to comment or push back, is it's really hard to see how just any contract with a institution kind of might be able to be regulated by the department. That seems, based on the statutory language, the justification, the regulations, kind of a little far afield. So one potential area to think through is the department's underlying justification for kind of how we're getting there. What actually is a third-party servicer, and what does it mean to be intrinsically intertwined? And that I hope the department will address as part of their potential revisions moving forward. And the last piece we want to, or one of the last pieces we want to talk through is Ed's motivation. Now, the aspects that I mentioned, where the department specifically expanded the definition of third-party servicers: recruiting, retention, software. Now, for those kind of following the higher ed community, that those are all kind of functions performed by online program managers or OPMs. Now, OPMs have been significantly in the news recently. There has been a big policy debate in this administration and prior about the benefit or lack thereof of OPMs, and that is not the point of this conversation to kind of weigh in on this, but suffice it to say, it is the area the department is really kind of concerned about, and the area the department is really trying to key into. As those people who kind of followed the initial guidance on February 15th may remember, the new third-party servicer guidance was accompanied by announcement that the department is reviewing the bundled services exemption in incentive compensation. That is another key concept of online program managers of these OPMs, and kind of putting together in this lens makes clear the department is kind of really looking to address the OPM relationships and maybe certainly figure out how to provide a tighter box around them and greater oversight that the department can kind of control. And we also mentioned in 2022, the GAO specifically published a report saying the department has to conduct or should be conducting greater oversight over OPMs. And with that, I'll throw it back to Hope.
Great. Thank you, Scott. So as a general remark, as Scott just wrapped up saying, as you start to think about submitting comments, which is what I'll be discussing for the next few slides, keeping in mind the theme that the department is troubled by a specific group and has put out guidance with the intention of expanding the definition of third-party servicers to include that group, understanding that motivation and having that background as you think through authoring comments will lead to the most effective comments. The most effective comments will understand that motivation and will avoid undercutting it. So to talk through a few of the logistics of submitting comments, as Aaron mentioned at the top, we recognize that it is Monday and the department has set the comments due date for Thursday. We want to note that for purposes of avoiding confusion, when the department put up the original version of the DCL, they gave a March 29 deadline. It has since been revised and now the deadline is March 30th. So we're talking about 3 days from now, but there is still time. As Aaron detailed, these don't have to be pages and pages, and they don't have to include legalese. They can be 1 or 2 pages, and all you have to do is write them up and hit send. It's a very simple process. And we also want to point to the fact that the department really wants people to comment. The department is not everywhere all at once. This is essentially a team of 25 to 30 people who are doing this and lots of other things. And to their credit, they acknowledge that they need help from the regulated community in order to build guidance that is well conceived. So it's important to offer feedback so that the regulated community can be considered as the department develops guidance like this. And lastly, as a final reason for why submitting comments is worthwhile is that we, through our firsthand experience, have seen changes suggested in comments from ourselves or our clients and have seen those directly impact guidance or new regulations. So we know firsthand that it really does make a difference and that it's absolutely worthwhile to chime in. So with that in mind, we also want to highlight that individualized comments are going to be the comments that are the most effective. So the department uses software to scan comments that come in. And if the department gets 1,000 versions of the same 2 paragraphs, the software is only going to read those 2 paragraphs one time. So while it's fine to copy and paste from the suggested comments of a trade group, perhaps, or an email listserv, is much more effective for you to discuss specifically how the guidance would impact you. So perhaps if you're an institution, you have study abroad partners or clinical relationships with hospitals that could be impacted by the new guidance. And examples like those are definitely concerns worth highlighting in the comments and concerns that we feel confident the department would like to hear about. So just as it is important to keep in mind the department's motivations for this guidance, it's also important to understand what's in the regulations and statutes. That's why Aaron went through that at the top of this presentation. And as he highlighted, guidance is not law. In fact, the department itself has acknowledged that a Dear Colleague letter is at most an interpretive rule, not a regulation subject to the notice and comment rulemaking process under the APA. So distinguishing between a regulation and a statute and guidance helps us understand that some of this is hardwired into how the department has to behave. So the department can't touch regulations and it can't touch statutes through guidance. And that's how we know that the department is more likely to revise and reconsider positions that are new and unsupported by law. Those are the soft spots that can be used as entry points for suggesting revisions to the department's guidance. So with that in mind, we would like to highlight a couple of critical concepts that are absent from the law. Again, Aaron discussed the regulations and statutes earlier at the top of the presentation. I'm going to discuss some things that are absent from the law. And again, these represent potential soft spots that could be used as entry points for entities to get themselves out of the quote unquote third-party servicers box. So first of all, nowhere in statute or regulation is there a prohibition on contracting with a third-party servicer or its subcontractors located outside of the U.S. or owned or operated by an individual who is not a U.S. citizen or a national or a lawful U.S. permanent resident. So as we detailed earlier, this concept first appeared in 2020 guidance, not statute, not regulation, 2016 guidance, and it shows up here again in this 2023 guidance. That is one of those soft spots that is unsupported by law and we believe could be a real opportunity for revision and reconsideration. A second opportunity is that nowhere in statute or regulation or prior guidance is there any suggestion that third-party servicers would include servicers assisting with recruiting, retention, or the delivery of academic programs. So this doesn't even have the support of prior guidance, nor does it have the support of statute or regulation. So again, this is a place where there's potential flexibility and your entity could use it as an entry point to make a convincing argument for revision and reconsideration. Before we move on to the last leg of our presentation, we have our second secret word of the day. The second secret word is recruitment. Please select the word recruitment. Yes, go for that.
And I was just going to say, I'll jump in while folks are, while we're burning our 30 seconds here. And just, you may be saying right now, boy, Thompson Coburn is sure selling comments pretty hard. I mean, we do think it's important to comment. There's, as most of you are paying attention know, an unprecedented amount of rulemaking activity and sub-regulatory activity coming out of the department right now. I really think it's fair to say maybe ever since the founding of the department. It's quite extraordinary. And it is important for the regulated community to be involved. But this in particular represents a really significant issue for a couple of reasons. I mean, one, Hope has said several times, it's guidance, and there's a lot of opportunity here to impact that guidance. But beyond that, I also want to highlight, going back to Scott's earlier comment that the department has indicated that they want to get into a actual rulemaking to revise the regulations around third-party servicers. Some of you may have asked yourselves, well, why is that? It seems odd that the department would announce a rulemaking and then come out with a Dear Colleague, particularly one that's so impactful, before that rulemaking commences. That's a great question. And I have an answer for that and also a suggestion. The answer is, keep in mind, if the department starts a rulemaking right away, if they announce it as they've indicated they will in the next month, they will probably be doing well to put together a negotiated rulemaking carrying out before the end of the year. Best case scenario would be that they had a final regulation prior to November 1 of 2024, which means, for those of you familiar with the master calendar that governs the department, the earliest their third-party servicer regulation could become effective would be July 1, 2025, which, of course, is on the other side of the next presidential election. So I think this administration, which has real concerns about the regulation of OPMs and does not want to wait until July 1, 2025 to start regulating them within a new regulatory framework, even if they're successful in carrying out the rulemaking, who knows who the next guy is going to be and how their administration is going to oversee or manage third-party servicers, right? Whether there might be a Congressional Review Act opportunity. I mean, it's just we have no idea, right? So this administration's looking at the 18 months in front of them before the next election, and I suspect trying to figure out ways that they can, in addition to trying to effect permanent change through the rulemaking process, begin immediately trying to capture OPMs and others that they would like to regulate directly. So you put out this guidance. But what's interesting is, typically we don't get a really good understanding of what the department is intending to do until negotiated rulemaking starts and they start revealing their sort of draft proposals for regulation. Here, the department, in putting out this guidance, has really shown us its hand. It's been very upfront about its objectives and where its thinking lies, with the result that you probably have a pretty strong sense now as to what the department will be trying to accomplish when it revises the rules surrounding third-party servicers. And what that means is we have, as a community, a somewhat, in my experience, unique opportunity to sort of comment twice, because the comments you're submitting now not only have the potential to shape this near-term guidance, but they also have the potential to shape the regulatory reform that the department proposes later this year and that you'll get another cut at. So you've got an opportunity, which is a fairly, if not unique, unusual one, to try to impact even the early drafts of the department's new third-party servicer regulation. So it just means that this comment opportunity has additional import, right? Even more than what you might normally see. Okay, so now having sold you so hard on submitting comments, we're going to talk through some points for consideration. Scott and I, in particular, have presented in the last 3 weeks to the National Association of College and University Attorneys, to the financial aid folks in New York, to the Forum on Study Abroad, and I only highlight that to say this may be the first time in my career that so many different segments within institutions of higher education have been so interested. We also presented to Insure. So you've got, lenders and guarantee agencies and study abroad folks and general counsels and financial aid folks all interested in the same issue area. And that's pretty unusual. One of the upshots of all that discussion has been a lot of highlighting for us in the back and forth of the kinds of issues that are of great concern. And we wanted to convey that to you all as you may think about formulating comments on a go-forward basis. So we've talked a lot about, first up, the foreign ownership restriction. As Hope and Scott, I believe, noted, it's been in the guidance since 2016, but it is not in statute or regulation. I think the import of this particular piece of this regulatory puzzle is fairly clear, but let me just hit it again. It's one thing to be deemed a third-party servicer and have to deal with the administrative and regulatory burden that Scott talked about in the section on TPS responsibilities. It's another thing to be prohibited from being a third-party servicer altogether. And so, as I think Scott used the phrase, an existential threat, if you're a company right now that provides services to institutions of higher education, you have foreign ownership, and this would mean that you could no longer contract with institutions. Obviously, this is a very big deal and a big concern. Again, what's interesting is the department seems to recognize that and be open to comment on it. They're actually specifically soliciting comment on this provision. We know it's not based in statute or regulation. I want to highlight, the ramifications. Study abroad is a big concern, right? I mean, now that third-party servicer would include entities and organizations that engage in academic partnerships with institutions of higher education, that could mean study abroad partners. The University of Madrid overseas that's providing part of your bachelor's degree program. It depends on how that contractual relationship works. They could now be a third-party servicer, except that they can't be because they're outside the country and foreign owned. So that's one of the Forum on Study Abroad, and a lot of the study abroad providers are extremely concerned about this. The current formulation could also restrict foreign recruiters, right? Because if you've got a subcontractor that's outside the country that's helping you recruit for a Title IV program, they would be covered. of course, the problem is you're going to be hard pressed to find someone who's resident in the United States and who can recruit as effectively in Africa as someone who is resident in Africa and is aware of the, all the systems and the prospective students and where all those folks are and what their needs are, et cetera. And then there could be other types of foreign service providers. And you as institutions may have a sense as to who those might be, who are, I don't know, helping to facilitate a study abroad experience or something along those lines. And they're not another institution. They may not be providing part of the academic program, but maybe they in some way are captured by the notions of retention or recruiting or something along those lines as well. So there are a lot of really significant ways that this interpretation of the rule could significantly impact institutions. If you're going to comment to the department, we think it's always important to start with a statement of, why whatever it is that you think is going to be negatively impacted is important. So in this case, academic partnerships with foreign institutions are clearly, extremely important to higher education and to cultural exchange in the United States. Native recruiters, right, are in the best position to most effectively work with foreign students and understand their needs and requirements. It's also really important to understand, if you can, where the department has revealed it, the basis for their position. And here they have, and they've asked you to comment on it. So the department has said, look, a big part of our concern here, and the reason we took this position is because we are concerned we can't recover effectively against foreign third-party servicers. Meaning, if you've got a third-party servicer that's foreign-owned or outside the country and they end up owing a liability, how will the department actually recover against them, right? So that's the concern the department has expressed, and we think there are a number of points that can be made to the department that speak directly to that underlying concern. First of all, most of the foreign academic partners and recruiting partners probably aren't if at all engaged or minimally engaged with the processing of federal financial aid. And why is that relevant? Well, because it probably makes it less likely that their activity would result in a significant liability to the department, right? I mean, if you've got a classic third-party servicer that's managing money and making eligibility determinations and servicing loans, there are a lot of places where if something went wrong, it could result in a liability to the department. If you've got a foreign recruiter in Africa that is strictly engaged in recruiting international students overseas, it seems less likely that their activities would result in some sort of financial liability to the department. Ergo, the underlying risk the department has identified here may not really exist. Secondly, and I know this is cold comfort to the institutions on the line, but it also is a fact that third-party servicers are jointly and severally liable, but they are not solely liable to the department. The institution is always the first recourse to the department if there's an exposure or a liability, right? So there's really no scenario, unless an institution has potentially gone out of business. But in most cases, if you have a third-party servicer, assuming the institution still exists, the department could always seek to recover against the institution. So it's not as if the third-party servicer being foreign-owned or outside the country would leave the department with no avenue for recovery. But finally, and maybe most significantly, and obvious to some of you on the line, I'm sure, domestic institutions of higher education can participate in and manage the Title IV programs even if they have foreign ownership. Not only that, but Congress permits foreign institutions to permit directly in the Title IV programs, certain foreign medical schools and foreign vet schools, for example. So what's interesting is Congress, in two separate ways, has considered this issue of allowing entities that are either foreign-owned or outside of the country to participate in the Title IV programs, and in both cases seems to have gained comfort that that does not create an untenable exposure for the taxpayer, right? So and this is powerful, right? So remember, we talked about the hierarchy of statutes and regulations and guidance. Here you've got our primary legislative body that has considered this issue on a couple of occasions and decided that it should not prevent participation. So that would seem at tension with the departmental position that having a third-party servicer with foreign ownership or that's outside of the country is so risky that we can't allow it at all, particularly when weighed against the extraordinary benefits that are provided by many entities that are foreign-owned or outside the country but work with our domestic institutions of higher ed. Finally, I just want to highlight, if you are going to comment, it's often a good idea. Some folks prefer not to do this, but it can be a good idea to sort of state your primary position, but also say to the department, if you're not able to accept my primary position, if you're going to stick with this position, then we would ask for clarity on the following points, right? So you're sort of, it's an if or. And here our thought was, if the department didn't want to back off of this position entirely, then in the least we would need clarity around when and how it applies. And just by way of example, we were sort of brainstorming and we said, well, how would the department determine whether a provider is located outside the United States? What if it's got 50 locations around the world and 20 of them are inside, the majority are inside the United States? Is it outside of the United States or not? What if you have an entity that has a 25% foreign ownership and 75% domestic ownership? Is it really disqualified? Or what if you have an entity that's foreign owned and a parent that's outside the country, but it has a domestic, subsidiary that is inside the country and oversees and holds the assets of all of its domestic operations? I mean, there are a lot of nuances here when you get into these questions of location and ownership that we think would need to be detailed by the department. That having been said, we also think that this is an issue where the problems are so significant that there is a high likelihood that the department would consider revising its position. And because it's not based in statute or regulation, we think that it would be easy for them to do so if they decided to. So it's a really good opportunity for comment. Recruitment is another one. And this, recruitment, retention, and instructional content are, sort of assisting with academic programs. All three of those are new. And we think in all three instances, if you wanted to, you could start out with, highlighting for the department, however kindly or aggressively you might like to, that there does not really seem to be a supportable link between the statutory language, which references, any aspect of your student assistance programs, and this notion that the department can regulate a party that has nothing to do with financial aid and is only providing academic programs or recruiting or retention, et cetera. So that's always a first line argument. But beyond that, there are some other things to discuss in the range of recruiting. I mean, one challenge here that we observe is that there's such variety in what is recruiting, so to speak. And those of you who wrestled with an incentive compensation prohibition, have thought about this and certainly appreciate that there are a lot of different kinds of relationships that can constitute recruiting or not recruiting or marketing or promotion, right? The activities undertaken by entities can vary widely from lead and contact generation to in-person recruiting to broad-based marketing. And the nature of the parties providing the services can vary widely, right? From lead providers to classic recruiters to employee benefits providers, right? I mean, I'm sure some of you are familiar. There are some large entities out there that they have relationships with employers and they help manage their employee benefit programs. And part of that may be highlighting for employees an opportunity for higher education at a favorable tuition rate. Well, does that mean that on behalf of that institution, they are recruiting those prospective students or employees? And if so, does that create a third-party servicer relationship? All of these partners, in theory, we think could be deemed third-party servicers. But it's unclear. And certainly it's a place where it's worth pushing the department. So that's what you see on this slide is our suggestion that, and sort of capturing this idea that there's such a wide range of services here, and that if the department should stick to its guns and say, no, we're going to take the position that recruiting is indeed intrinsically, intertwined with the student assistance programs, then I think it's fair nonetheless to push the department and say, well, then we need a lot more clarity around what types of providers would be covered, because, you have providers who may actually have nothing to do with students, nothing to do with, taking in tuition or other dollars or fees or managing financial aid in any way. And should we be distinguishing between those entities that are strictly engaged in some sort of marketing or recruiting activity and those that also, do other things and are engaging, like the OPMs the department seems so concerned about? So there's a lot of opportunity here. even if the department doesn't back down off recruiting altogether, there's opportunity to push the department to refine and expand the understanding of what types of activities are covered, and to argue to the department that certain types of activities perhaps really are not intrinsically intertwined and shouldn't be covered. I think retention's a really interesting one too, and it seems like something that's sort of been rolled in. It sort of feels like the department sat down and said, well, what are the three things most OPMs do? All right, recruiting, retention, and instructional content. Let's put those in the chart, right? But retention seems a little more problematic in the sense that, some entities that recruit, they may be recruiting on behalf of particular programs. They may be involved in managing aid. I think our main concern here, and we think a really good point of entry with the department for comments, is that there are a lot of organizations, including nonprofit and service organizations, that conduct activities in partnership with institutions of higher education that are extremely valuable to students and could be deemed retention activities, right? And these are not OPMs. These are not folks providing a broad suite of services, and many of them may be unwilling to take on the risk associated with a third-party servicer. You imagine sort of a small local nonprofit organization that is partnering with you right now to create opportunities for your students or to provide tutoring or instructional support or something along those lines. And then you have to go to them and say, well, now you can be audited by the department subject to program reviews and blah, blah, blah. And, it could have a chilling effect. One has to think that some of those organizations will say, boy, well, we're sorry we can't keep helping you out, but we're just not going to do that, right? And that's a problem. That if taken on scale across the United States, there are a lot of these types of relationships that have great value. And I think it's fair and, worthy of comment to push the department and say, look, we really need some sort of more nuanced understanding around, what kind of providers would be covered. Also, I'm just going to skip backward here real quick. But, if you look at the chart here, to the extent you can see it, and if you have the guidance, you can just pull up, the actual Dear Colleague letter. In the chart, the left side says, this is the stuff, if you do it, you would be a third-party servicer. And on the right side, it says, but here are some carve-outs. If you do this, you wouldn't be. And what's interesting is, in almost every other category, there's something in both sides of the chart. But for retention, the department says, if you do this stuff, you're covered. And there's no carve out. There's no sort of consideration as to whether certain types of providers or certain types of activities, despite sort of the general statement of being covered, would nonetheless be excluded. And that's interesting. And it seems like there's opportunity there too to say, hey, department, you've given us nothing here that we can use to try to discern whether some of these other types of entities might not actually be covered. And again, just not to beat the dead horse, but it really feels like a jump to say that anyone providing, academic tutoring or counseling or other types of retention services is somehow fundamentally, intrinsically intertwined with your administration of your student financial programs. It's also unclear whether all of those services are indeed required under statute or regulation. And remember, in the regs right now, the definition of third-party servicer, when it talks about, well, what do we mean by, any aspect of your Title IV HEA programs, it says, the stuff schools are required to do under statute or regulation. So if you've got entities providing retention services and those services aren't required under statute or regulation, it really begs the question, how are these covered under either the statutory or the regulatory language? All right. Our last secret word. Okay, well, this one I like. I'm going to give Jacob a reprieve. So our last secret word is regulation, which is the title of our blog. So good for you, Jay. I appreciate the teeing this up. So again, it's regulation or reducation. I've heard it pronounced different ways. So please click on that button. And after we get on with this, the last section we're going to get into here, there are two more. But the next one is instructional content. And I want to make really clear what we mean by that. I'm sort of getting ahead while you click your button. But earlier it says if you're assisting with the provision of your educational programs, just to be really clear, what we mean is if you've got a third-party servicer that is helping you to deliver some under contract, helping you to deliver some part of your academic program, not your federal financial aid programs, your academic programs, then the department is saying that provider would now be ostensibly a third-party servicer. Okay, I'm going to go to the next slide. So this is interesting. I think when you talk about unintended consequences, this is actually the one that has caused the department the most problems. And one thing I will propose for you all to consider, we were thinking about this earlier. What would be the easiest way for the department to keep most OPMs, which is its target? I'm not saying this is good or bad policy or they should or shouldn't. I'm just saying the department's been pretty clear that their objective here is to capture OPMs. So what is a way that the department from a policy perspective could keep most OPMs inside the box while getting a lot of these most problematic unintended consequences outside of the box? And it occurs to us that one way to do it might be to keep recruiting. In other words, if you're recruiting, then you're a third-party servicer, sort of consistent with their current guidance, but to take out instructional content. If you're providing an academic program, that in and of itself would not create a third-party servicer relationship, because most OPMs engage in recruiting. And worst case scenario, if the department took that approach, it would push OPMs that didn't want to be third-party servicers out of recruiting, which would probably make some of the current folks in this administration, that would probably please them to some extent based on the comments we've heard. But it also, by taking academic programming off the table, would probably resolve some of the biggest issues that have been created here. And you say, well, Aaron, what are we talking about? Okay. So for example, if you include academic partnerships, meaning anyone who's out there who under contract is helping you provide an academic program under the TPS umbrella, first of all, any other institution, Title IV, domestic, international, study abroad, that's helping you provide part of your program is ostensibly a third-party servicer, right? So if you've got a relationship with another institution where they're providing 1 year of your 3-year program, or your students are going over and studying somewhere else for 6 months, under contract, and it depends on how that relationship is structured, but ostensibly it could create a third-party relationship. Not only that, but you might become a third party, right? If you're providing part of a program for somebody else, despite the fact that you are both institutions of higher education. A hospital or other clinical provider providing internships or externships or clinical experiences could become a third-party servicer. I mean, this is a huge problem, right? A lot of institutions, particularly medical schools, those in allied health, some of them have hundreds of clinical relationships. I mean, how many clinical affiliation, externship, internship relationships does Ohio State have? They have 110,000 students or something in that neighborhood, right? It's got to be hundreds and hundreds and thousands. And across all of institutions of higher education, it's probably tens of thousands of clinical relationships. In this case, Scott mentioned earlier, when you talk about the burden on institutions of updating your ECAR, within 10 days of a new third-party servicer relationship, if you cover clinical relationships, it might actually be impossible to do this because your ECAR would be locked up all the time if you're an institution that has hundreds and hundreds of these types of relationships. Not only that, but what if you are an institution with a hospital, right? Or a state university system that operates multiple hospitals or other sites where you might actually be housing clinical sites. So now you're on both sides of it. You might be an institution that has third-party servicers that are clinical sites, and you might actually have hospitals that are becoming third-party servicers because there are institutions out there that are placing institutions and clinical relationships at your hospitals or other clinics, et cetera. It's a major problem. I think the department will back off this one, but it's important that people raise this issue, we think, and highlight why this is such an extreme issue. Also, if they didn't back off, I mean, we have a real concern that many smaller clinical providers, solo practitioners, private medical offices, et cetera, are just not going to do it. And for those of you who have programs that require clinical placements, we all know how hard those are to find. And if you suddenly have many, private practitioners or small medical groups that say, well, we're just not going to do this, that becomes a huge problem and has a real meaningful detrimental impact on medical education and other types of programs that have internships and externships and clinical sites. So all really good fodder for comments. And then finally, just to be sure we're covering all our bases, if you have an academic program and you have hired a non-institution to provide some of that program under contract, they become a third-party servicer. So let's say you have a criminal justice program and you've got a local police department that's offering part of the criminal justice program under contract. My wife, when we met, she was a commercial airline pilot. She got a degree from Jacksonville University in aviation management, and that university had a relationship with a flight school nearby. And as part of her bachelor's degree program, she got her flight training, right? Those guys would be, that little flight school would be a third-party servicer under this guidance. So those types of relationships also, it's important to be thoughtful about. Again, we think if you want to comment on this, it's important just to highlight for the department how critical many of these things are to higher education as a starting point. Academic and clinical partnerships are foundational, et cetera. Again, we highlight there's no statutory regulatory basis for including academic partnerships as third-party servicers, right? Nor is there really anything historically in the guidance that would suggest that this is an appropriate sort of leap. In fact, and this is, we think, terribly interesting, there's actually regulatory precedent leaning the other way. So some of you may know that written relationships among eligible institutions of higher education actually are governed under a different part of the regulations, 668.5. And there are, if you have a contract with another institution of higher education, there are a handful of things that have to be in that contract actually under 668.5. But what's interesting is this administration rewrote that regulation not too long ago, and they included a couple of things. One, there's actually a line at 668.5D2 that says, in the case of a written arrangement between two eligible institutions, the institutions can agree in writing to have either of those schools make the Title IV federal financial aid calculations and disbursements, and that will not create a third-party servicer relationship between those two institutions. So what's fascinating is, in the context when this department was creating updating the regulations that govern relationships, written arrangements between institutions of higher, Title IV institutions of higher ed, they actually had the foresight to say, but if as part of those relationships, one institution is managing financial aid on behalf of the students from the other, at some point in the context of those relationships, that does not create a third-party servicer relationship. So it's here in the regulation, this idea that they're excluding academic partnerships between institutions from the definition of TPS. Candidly, I think the current guidance is at tension with this regulation to some extent, right? I mean, it would seem to be. It's also worth noting that in that same regulation, 668.5, at the very end of that regulation in section H, the department says, also, by the way, if you've got a written relationship or arrangement between two parties, but that relationship relates specifically to internships and externships, then it's excluded. So it says the internship or externship portion of a program is excluded from the written arrangement if the internship or externship is governed by an accrediting agency. Then there's some stuff about foreign institutions, but basically says, and is monitored by the qualified institutional personnel. So again, someone had the foresight to say, hey, we've got this 668.5 that requires that institutions that have written relationships have to make sure their contracts say, a handful of things. But if this is just a clinical internship, externship type thing, we're going to exclude those. So it's fascinating. When they rewrote 668.5, they took the time to say written relationships between schools aren't third-party servicer relationships. And also, clinical arrangements don't even constitute a written relationship between two Title IV institutions. So if I was going to comment on this, and we have commented on behalf of some people, I think these are really good things to point out to the department. There's actually regulatory precedent for these exclusions. Finally, software providers. It's important, Hope made the point earlier that about 80% of what you're seeing in this new Dear Colleague actually already existed in another Dear Colleague, the one from 2016 and revised in 2017. Obviously there are some very new important things here, but a lot of it was already there. And one of the things that was discussed in the 2016 22-page Q&A was software providers, or specifically, entities that provide computer services or software. And actually it goes back even further than that, right? If you'll recall from the very beginning of the presentation, the regulatory text that defines a third-party servicer starts by excluding entities that provide computer services or software. And then the department sort of circled back around in 2016 and said, yeah, okay, but if you provide computer services or software and you still have certain types of access, et cetera, then you would be a third-party servicer. So they've maintained that basic construct, But in the new guidance, they've cast a much wider net, right? So that many more entities would now be covered. We took a shot at sort of formulating the new guidance in a way that we thought was a little easier to digest. So the way we read it, the department would still contemplate that some computer services or software providers would be excluded, but only if the following three things are true. First of all, the provider has no access to and maintains no control over the systems needed to administer any aspect of the Title IV programs. And remember, under this new guidance, that means recruiting, retention, academic relationships, right? And specifically that they have no ability to use or have view or update access to any student level information in any system used for the administration of any aspect of the Title IV program. Also, the products and or services have to reside at or under the control of the institution, right? I'm sorry, I misstated that. Let me be very clear. The products and or services have to reside at and be under the control of the institution. And finally, all of this has to be true. The provider does not perform any activity on behalf of the institution within a system through remote or automated processing. Well, if you really think about this, in our view, this is going to include a whole lot of different entities. I mean, first of all, anyone providing cloud-based software and service solutions, because those software and service solutions aren't located at the institution, right? And remember, I'm just going to click back on the prior slide here. The products and services have to reside at and be under the control of the institution. All right. Providers that retain access to systems to provide technical support or updates also ostensibly would be covered. In fact, we think this construction is so broad it would seem ostensibly to even capture ISP providers. Insofar as, look, their infrastructures are needed to administer many aspects of the Title IV programs. Hard to imagine administering, I mean, and keep in mind, again, under this guidance, any aspect, the department says that's academic programs, that's retention functions, that's recruiting functions, all that stuff. Well, it's hard to imagine doing all that without wireless, right? So they're needed to administer many aspects of the Title IV programs, and they're not under the control of the institutions, nor are those infrastructures entirely located on campus. So it's a real problem. And we think that a lot of folks, software providers and others, may be commenting, but we, just as with the other areas that we ran through previously, we think this is one where there's real opportunity to highlight some very real practical concerns to the department. And again, the goal is, as Hope stated, to try to highlight this stuff in a way that says, department, we know what your stated objective is here. It's OPMs. But we've got all these other problems that have been created. So here's a way that ostensibly you could continue to keep OPMs inside the box, which is your stated objective, while also trying to be thoughtful about all of these other issues and maybe get them outside of the box so that we're not harming students, faculty, and staff and institutions. Finally, if you are so inclined to take this route, in addition to sort of pushing back generally, you can also say to the department, if you're going to keep something like this, there are some things that certainly we believe should be refined and clarified. All right, so that's the end of the presentation. I'm going to hit a couple of points here, and then we will go to questions. First of all, as Scott so generously noted earlier, we have this is our blog, actually, and all this stuff's free. We're happy for you to read our blog, sign up, subscribe. We would love for you to do that. And again, there is a free webinar tomorrow, same platform, specifically about federal student aid issues and GLBA compliance. We also, all our webinars, including this one, are available on demand after the fact. You can't get continuing legal education credit if you listen to the recording, but you can hopefully still derive some benefit from doing so, and we would love for you to do so at your convenience. And finally, we do have a lot of compliance materials that we try to periodically put out compliance materials. And I will note, for the proprietary institutions, we have a new version of our 9010 rule compliance white paper that we're going to try to get out on the wire here very shortly. So keep an eye out for any of those kinds of things. They're free. We put them out there just like these webinars because we want to be helpful to the community, and we'd love for you to have them. That's why they're out there. Finally, our disclaimer: we're not your attorneys unless we're your attorneys. So with that, I will click over here to the Q&A. All right. And we do have some questions. So I'm going to scroll back to the beginning. All right. All right. Does this include affiliation agreements for clinical training? So I think we covered that. Yeah, we think that the new TPS guidance is construed broadly enough that unless the department amends it, it would appear to cover clinical trainings and externships, at least many of them. Again, it kind of depends on how the contractual relationship works, but our expectation is, at least on its face, that it would probably apply. My hope is that there may be some way that the department can sort of define what constitutes an externship or internship or clinical relationship in a way as to say, well, we don't really consider those contractual relationships. Those are actually part of the program or something like that. And we'll see. But for now, we definitely think it's a problem, and that folks should comment on it if they're inclined to do so. How does this apply to a university system in terms of whether or not it would be considered a TPS? Scott, correct me if I'm wrong, but two things. One is one of the trade organizations early in a letter to the department seemed to imply that there might be concern here. But my recollection is there's pretty clear language in the Dear Colleague letter that speaks to this point. And the department actually says, if you're a university system or you're otherwise under common ownership and you've got a parent entity or some other entity within the ownership structure providing services, that would not create a third-party service or relationship. Scott, does that ring true?
Yeah, sorry, 100% it does. In the guidance, it's Gen Q8. And the answer is it depends. And I'll just really briefly, if an eligible institution performs functions on behalf of another institution with the same legal, corporate, or shared governance system, e.g. a public system, the institution performing the functions would not be a TPS. So just encourage the poster to take a look at that. But obviously, the department's saying it depends. There is still some nuance there.
Yeah, and what's interesting is this is actually a potential improvement. And I should note that, we always focus on all the places to criticize or push the department to revise. If there's something you see that works, you can always let the department know that you agree and support that. And actually, in the past, there was not a carve out like this. And we worked with some university systems where there were certain services being provided at a parent level or a system level, and the department once upon a time took the view that did create a third-party service or relationship. So, I think this is actually sort of based on experience, a useful and appropriate maturation of the department's policy in this area. Let's see. Is subcontractor more clearly defined? For example, must a subcontractor be another company, or can it be an independent contractor? I don't, Scott, correct me if I'm wrong, or Hope, I don't recall anywhere where it's specifically defined, but I think the department's view would be, if you've got a contractual relationship with a third-party servicer and that entity is contracting with some other party to help carry out its primary functions, that other party is a subcontractor for purposes of this policy. Scott, Hope, what do you think?
I'll start. Yeah, I think that's right. And I'm just checking the guidance now, and there is no definition. So again, this might be a place to ask for guidance or to request that this be clarified. But I think absent any kind of meaningful guidance, that Aaron's definition is the exception one that we should consider.
Yes, but you should do what Scott does, which is actually look back at the policy. That's a good practice. Hope, go ahead. Sorry, I think I cut you off there.
Oh, no, I just said I agree with Scott's analysis.
I know. Scott has good analysis. Let's see. I think I've got someone here who said, this is a big concern for us with curriculum providers and they've named a particular provider that I think is known to have foreign ownership. And I'm assuming that this comment relates to the problems created by foreign ownership. So yes, I think there are some very large providers out there right now that provide assistance with, whether they be an OPM or sort of a more classical provider of academic content and support. But that believe they would be covered by this new definition and that have foreign ownership. And for all the reasons we discussed previously, I mean, you can bet those guys will be pushing hard and lobbying hard. And if the department were not to come down off this position, I mean, I would expect those will be the folks filing suit, right? Because it would impact, you know, I assume would materially impact their business. And that's a big problem. Let's see. This is a long question. I thought you said earlier that companies providing, that's always dangerous when a question starts out that way. It's disconcerting. I thought you said earlier that companies providing computer services or warehousing of records were not considered third-party service. But later you said that the broadened definition includes providing software products and services involving Title IV administration activities. Did I hear that incorrectly? No. This is a great question. And I'm glad you asked it because it's a point worth hitting again. So, and I, you know, being a regulatory attorney, I tend to think a certain way, and sometimes that's helpful and sometimes it's not. But the way I think about it is this. So the department, the statute starts and says, this is generally what we consider to be a third-party servicer. And then you have the regulation that says, yeah, we're basically going to restate that. But we're going to include some examples, and then we're going to include a few specific exclusions. So this is in the regulation, in the current regulatory text. There are 6 types of activities that are excluded from the definition of third-party servicer. And interestingly enough, one of those is computer software and service providers. So if you'd never seen any departmental guidance and you only went and read the statute and regulation, you would probably come away and say, well, computer software and service providers are excluded. But then the department, beginning in 2012 and subsequently, has made very clear in its guidance, well, okay, so there's a general exclusion. But to be clear, you would be included nonetheless if you have certain types of access or engaged in certain types of activities. And what the department has done is, so what's interesting is the department's guidance is effectively a carve out from the exclusion. Does that make sense? So the regulation excludes computer service and software providers, but then the department has said, okay, but we got to carve out from the exclusion. And their carve out is so broad that it effectively covers almost all of them, right? Rendering that regulatory exclusion almost meaningless. And my expectation is when the department goes to rewrite these regulations, if it gets around to it, as it says it's going to, I suspect that that exclusion will come out altogether, because I think it's probably a sore spot for the department right now. It really, I mean, you've got a rule that's gone through the Administrative Procedures Act rulemaking process that excludes a group, and then the department is, through sub-guidance, effectively putting almost that entire group back into play and covered by the definition. And that's a question, right? I mean, it feels like they're changing the rule without changing the rule. So, you know, if I were suing the department down the line, you know, you got to decide when you make comments how aggressive you want to be, of course. But if I were, you know, suing the department, that is the kind of legal argument that I would probably make. And I don't know that I think it is a bad one, candidly, because you're not supposed to change rules without going through the rulemaking process. And if you interpret something in a way that basically renders a rule, you know, moot, there's an argument that that's exactly what you've done. All right. It's a great question, and it is a little confusing. Were you surprised by the list of covered functions, such as a TPS assisting with consumer information disclosures? Yeah. So here's what's interesting. I was certainly surprised with the inclusion of retention, recruiting, and academic program support, because that's never been seen anywhere. And as we've noted throughout the presentation, we think that's a stretch. I was not surprised by consumer information. And let me give you 2 reasons. The first is consumer information and consulting generally were in that 2016 guidance. So this isn't the first time we've seen that. But the other thing is, and this is an important point for everyone to understand, because I don't want you to waste a bunch of time on comments on consumer information, because here's the thing. The statutory language says, you know, if you contract with someone to help you with your student assistance programs, And then the regulatory language says, yeah, anything that's required under statute as part of your participation in the Title IV programs. Well, here's the thing, that consumer information stuff is required as part of your participation. That's in regulation, right? I mean, having to give all that financial assistance information and academic and institutional information, having to distribute that annually, your student right to know, your Clary Act, all of that stuff is in the regulation. And you are required to do that by virtue of being a Title IV participating institution. So if you are hiring a third party to assist you in the creation and distribution of those items, is a pretty good argument that that party is a third party servicer, or might be a third party servicer. I mean, I think maybe there's some nuance there between creating the policies and distributing them. The regulation doesn't require you necessarily to, you have to have the policies, but in some respects, it speaks more to sort of the distribution of them. I don't know, but consumer information is part of your Title IV participation. So I was not surprised to see it. And I actually think, telling the department, I don't think some entity that helps me distribute my annual security report should be a third party servicer is probably not going to be effective, right? Because that is a statutory and regulatory obligation as part of your participation in Title IV. But it is not one that we classically think of as being part of student financial assistance, right? And part of the financial aid office. So it is, I agree with you that it seems like it shouldn't be there, but it probably should. Let's see. Hello, and thank you for the webinar. Thank you for the kind words. You mentioned that previous expansions of third-party servicer guidance have been due to the department being troubled by a specific theme. Can you reiterate, expand on what the theme is in this case? Oh yeah, it's, as Scott mentioned, it's OPMs. Very clear, right? It's actually expressly stated on the front of the first page of the Dear Colleague. And again, the fact that they bundled this with incentive comp at the same time, that's the only real reason to bundle those two announcements together, is because they're both getting at OPM providers and relationships. Will you the participation? Oh, will you share with us the participation today? I'm not sure what that means. I mean, I think we have 200 or 300 people on the line, actually, which is great. And we have folks from institutions and servicers and regulators as well. So very grateful for everyone tuning in. Let's see.
I heard to the extent that shared the presentation, maybe that's what the commenter meant.
Yes.
That just a reminder that it's all online on our website, and feel free to view, and please do.
Absolutely. If you meant share the participation, I think it's what I said. If you meant share the presentation, it's in the resources widget. And if you can't get a hold of it for some reason, just let us know and we'll get it to you. Let's see. I heard a Department of Ed official state that schools should send their contracts to the department for review and determination. Obviously, it's not an ideal solution for determining if a vendor or class. Yeah, well, this is interesting. So and one thing we didn't really cover in the presentation is what we think schools and vendors ought to be doing right now. I think as a general matter, over the next 3 days, I would, if you're interested, focus on commenting, right? Because you got a deadline coming. And then after that, and I had the opportunity to do I mentioned earlier, a presentation with a general counsel from an institution. And he was sort of talking about this from his perspective, and they have a large study abroad programs. And, I agree with his take, which is, evaluate your relationships, try to decide who you think might be a third party servicer under the existing guidance. You could choose to communicate with some of those folks and just see where they stand. But I would not. I had one presentation, somebody asked me, like, should we start canceling all our study abroad programming today and telling students they could? I said, I would not do that. So I think, speculating here, I think there will be significant revision to this guidance. I think the department understands it has some significant issues to manage. And I would not start taking drastic steps at this point in time. Now, if you're an OPM that does recruiting and academic support and retention and helps manage finances, and come on, at this point, it's probably a good bet that you may be covered. I would at least be planning for that contingency. But, if we're talking about, if you've got someone who's a study abroad partner or a foreign recruiter or, or a clinical relationship, I certainly would not take any dramatic actions because we think a lot of those issues the department understands need to be addressed. So I would sort of catalog, I would talk with other folks in your institution that may be impacted. You could have those conversations with TPSs, but I would mainly do preparatory work at this point in time and keep an eye out for the guidance. Now, by the way, let me just stop. Scott, does that sound right? Hope? Additions to that?
No, that sounds perfect. Yeah. Yeah, and I think cataloging, assuming or hoping it's going to change, potentially it does, cataloging your contracts that might be covered under this one is a helpful exercise. And then you can hopefully cross them off the list if the guidance does change.
Yeah. So the other question was getting specifically to this question of should schools be submitting specific relationships to the third-party servicer group there in Kansas City? My advice, and I understand the official's point was, well, if you've got questions, maybe you should ask. First of all, keep in mind, a third-party the department doesn't evaluate entities to determine if they're third-party servicers. They evaluate specific relationships. What do I mean by that? You could have a company that is contracting with 5 institutions of higher education. And under one contract, it's providing a suite of services that do qualify as a third-party servicer. And under the other 4, it's not. So it's not, you're not a TPS for all relationships or none. Each one, it's based on the specific services being provided under that particular contractual relationship, which means even if one institution had a relationship with a company and went and asked the folks, in Kansas City, is this a TPS? The folks in Kansas City might say yes. And then you mention that to another school, and the other school could ask the same question, and they might come back with a different answer. So, you've got 6,000 institutions of higher education in the United States. Who knows how many relationships they have that ostensibly could be TPS relationships, particularly if this covered study abroad and clinical, right? It could be literally tens or hundreds of thousands of relationships. And also, you can't get one determination for each entity out there. It would have to be for each specific contract. I say all this to say, while it's easy for someone from the department to say, oh, yeah, if you got a question, just reach out to the folks in Kansas City or wherever, and, they can look at the contract. In theory, that may be true. But I think right now, it is unlikely you're going to get, well, let me put it this way. I won't speak to what the department can or can't do. And I know the folks over there, and they're very hard workers and they're good people. My point is just, if everyone started submitting all of their contracts to the department to have them reviewed and signed off on, I think the department would be receiving tens of thousands of potential contracts, and that probably would not be manageable. So I don't think the department has a formal process in place. I don't think the department is suggesting that there is or should be a formal process where everybody gets every relationship vetted in advance. I think maybe what this official was speaking to was the idea, look, if you think you're right on the line, or if you're a vendor and you're trying to understand if a particular set of services that you provide to lots of schools would qualify, maybe then it makes sense to reach out right now. I'll just leave it at that. Scott, does that sound, Hope? I just can't imagine that if everybody's...
Yeah.
And I think there's also value in, if you're unsure, being on the record with the department that you're being a good member of the higher education community and doing your best and
Sure.
and kind of having that record. But potentially you might not expect to hear back by September 1st, I'm sorry.
Agreed.
Did have one person, and I think this will have to be our last question, but we had one person ask a question about sort of, I'm trying to think about how to characterize this. And I think this was in response to my comment that maybe what the department could do would be keep recruiting, but remove instructional, and maybe that would capture OPMs and the question was, well, wouldn't removing the bundled services provision accomplish that? If you do any type of recruiting, whether bundled with other services or not, you would be a TPS. I sort of want to use this question as a jumping off point just to say, I think it is easy to do, but important to avoid conflating incentive comp. And I'm not suggesting this questioner was doing this, by the way. I'm just using this as a prompt to have make this point. But it's easy to want to conflate incentive comp and the TPS guidance, especially because the department made this announcement on the same day, and because both get right at OPMs and have been a big part of the conversation around sort of how to regulate and think about OPMs. But they are different regulatory frameworks. And I just want to be really clear, you might be engaged in covered recruiting activity and as such be on behalf of a school and be covered by incentive comp, right? And you might also, by virtue of being engaged in a recruiting activity, be a third-party servicer. But what constitutes a covered recruiting activity for purposes of incentive compensation and what constitutes recruiting activity for third-party servicer are not the same, at least not the way this guidance has come out. And we're a long way from, and I think it's dangerous to think of it that way. For example, marketing and promotional activities and most, a lot of recruiting activities that don't involve any kind of direct contact with students could be exempt from incentive comp. I don't want to say are, but, in some cases certainly would be, right? But they might not get you out from being a third-party servicer because that sort of concept around, what types of recruiting activities constitute third-party servicer activities is different. Remember, the department's starting point is almost everything is inextricably entwined with the administration of the Title IV programs. That's much broader than the incentive comp guidance. So I want to be really clear. It's important. Don't look at incentive comp and the 2011 Dear Colleague around incentive comp and try to divine or use that to inform your conclusions around whether you might be a third-party servicer or not. You got to really focus on the third-party servicer guidance for that side and the incentive comp guidance for that side. And I know it's confusing because they've been talking about these sort of in tandem, but they are separate regulatory frameworks, and the guidance for those frameworks is really independent of one another. Hey, that's puts us almost out of time. We so appreciate everybody tuning in. We hope this was helpful. I know it was a lot to think about, a lot of feedback. If you have a chance and you're interested, we hope you'll think about filing comments because this is an important issue and it's a good one where a lot of schools and vendors have important things to say. And just one reminder again that tomorrow's the webinar on Gramm-Leach-Bliley Act compliance and FTC compliance, and hope you have a chance to tune into that if that's something that would apply to you as well. With that having been said, be well, and we'll see you next time.